Previously on balls.co.za.
Martin Hood, welcome to the show.
Afternoon, guys, listeners. Hi.
Nice to have you with us. And you basically represent gun lobby or gun owners.
Yes, I represent gun owners. I've been involved with the South African Gun Owners Association.
Okay.
I represent firearm dealers, some of the hunting associations. I'm also involved internally with some of the organizations, what we call accredited organizations, helping out with some of the internal issues. I've been involved in the drafting of legislation relating to firearms in the security industry since approximately 1997. I'm pro-gun, let me make that absolutely clear. I fight for firearm owners' rights, both politically as well as in the courts. Do a lot of litigation about firearm rights, firearm ownership, administrative law relating thereto. And of course, firearm owners in general have got a very strong interest in the Pistorius trial because one of the captions that you might see in some of the visual media is guns on trial. And that is exactly what's happening. So I and various other organizations keeping a sort of watching brief on matters to make sure that if anything is said or done that requires some sort of level of rational comment on behalf of legal firearm owners, we can put it out there.
Yeah. All right, let's just try and get some kind of comparison. And I'm one of the people that's obviously followed the big gun control debate in the US. Obviously, people like Piers Morgan have been very vocal about it, and there's a big school of thought that, and I wouldn't be surprised, I wouldn't dispute it, that the reason why he's lost his show is because he took on not necessarily the NRA and the gun owners, but the Second Amendment in the US.
I think also with Piers, it's all very well and good for any member of the media to have some sort of personal bias or personal feelings. It's natural, but with Piers in particular, I think he went a little bit overboard in one particular direction. And I think people realized that he couldn't actually objectively deal with that particular subject matter, and the end result is he got the chop. It's a pity. I'd have loved to have had a debate with him. Yeah,
well, I mean, and that's the thing. You say he couldn't be objective because it was a very subjective from his side. He got very angry in some of the interviews. It was obviously his thing about gun control. You could see where he was coming from in certain ways because of, that whole debate just there, by the way. I don't understand why it hasn't just come down to the fact that, guns in the hands of responsible people are okay. It's checks and checking for people that might have some kind of mental instability and stuff. You wouldn't want to put a gun in their hands.
Absolutely. I think you can sum up the gun control debate very simply, and that is that we always have had and we always will have some controls. And I think most rational people understand that that is necessary, that you don't want to let any Tom, Dick and Harry who may not be competent to have a firearm because
like
it's
John.
great. Well,
yes.
I can't speak. Apart from the hairstyle, I can't speak for John. But
thanks.
Do you have a gun, John?
Yes, and I have had one for 30 years.
Now, you see, there's something now. Do they do background checks here in South Africa?
Well, they do. Yes. Well done, John, for
Thank
getting
you
through
very much. Thanks.
Seriously, no one's going to argue that some level of control is necessary.
And there is gun control there is a level of control in South Africa
Well,
compared to America, for instance.
There's a very high level of control in this country. In fact, we're one of the most controlled countries in the world where firearm ownership is allowed. America, it's not so easy to sum up because they've got different levels of control depending on what states you're in. They've got federal as well as state legislation. So you can't say that something applies across the board because generally it doesn't. But in this country, we've had gun control since the settlers in the 16th, 17th century.
Because in America, the problem not necessarily because they do have laws, obviously, about how you carry if you're a gun owner. But I think the big issue there is being able to walk into a Walmart and walk out of there armed to the teeth with a gun.
Well, it doesn't. See,
with a driver's license.
It's actually not that simple. First of all, most states, there's a background check that's required in any event. So you can
there?
Yes. And the difference is that in America, it works relatively quickly because you go into your local gun store. You can buy a gun in certain states over the counter. And I'd rather call it a firearm, by the way. A gun's got negative connotations attached to it. You can buy a firearm over the counter. Some states have some sort of pre-licensing requirement, like a concealed carry permit, for example, or requirement that you've conducted certain certified training. You go into the firearm shop, you buy your gun, they send your details through to the FBI, and it's supposed to be an instant background check. So in the vast majority of cases, your report is given straight away, yes or no. But they've got an interesting provision there as well, that if there is no negative report in 72 hours, you can have the firearm. So that puts the onus upon the state to actually do its job quickly and efficiently. And it works.
Because, I mean, so, you know, especially with these school shootings they're having over there as well, that debate as well about, you know, arming teachers and stuff like that. I don't agree with that, because you don't know how competent these, you know, even if you take them through a certain amount of training. That's, to me, it's like rather get reservists and people that have actually operated and been trained with guns and have them on premises to discourage any kind of crackpot or, you know, loose cannon from walking in there and just, you know, taking liberties. They think twice about it if they knew that there were people that are trained, and not necessarily your teachers, but reservists, people like that, you know, people that have been part of the police force or had that kind of formal training on premises to kind of try and discourage what is becoming a big problem in the States and has been for a while.
Well, you can see I've got my thinking face on, because that's a very complex debate about the school shootings, and I think we need to just consider a couple of things. First of all, in most of those cases, if not all of those cases, there were certain key indicators present. One was psychological disorders on the part of the child, and that was related to the type of activities that they were engaged in, such as a lot of these violent video games.
Yeah.
And I'm not blaming TV or violent video games, it's a characteristic. And then there's a train of thought as well about certain medications that tend to aggravate that type of behavior. And then you say you shouldn't arm teachers. I disagree with you, but I don't want to say a teacher or a pilot for that matter. What I want to say is there's very strong evidence that shows where you've got a legally armed population, and of course if it's legally armed, they've been trained, they've been certified, they've got a legal firearm, etc., then there's a much lower incidence of random shootings. These random shootings take place in what are known to be gun-free zones. A school is a gun-free zone. So there you've got a sector of the population that's vulnerable.
Yeah.
So I believe that you should arm teachers who are suitably qualified. And I'll tell you a little anecdote. I had this told to me by the person involved back in 2000 when I was in America at the National Rifle Association convention. Can't remember the lady's name, but she was a senator of one of the states, pro-gun senator. She saw her parents shot in the head in one of these roadside cafes, because her gun, by law, had to be locked in the cubbyhole of her motor vehicle that was sitting in the forecourt where she could see it.
Yeah.
She could see exactly where her firearm was. And two guys walked in and they started one of these random mass shootings. And they knew that by law, the people in that particular state could carry a firearm unloaded in their car, but they couldn't take it into a public place. And she became a pro-gun advocate because she watched both of her parents, unfortunately and very tragically, getting shot in the head. She was shot as well, but she survived. And from that day onwards, she became an advocate of what's called concealed carry. In other words, allow civilians to carry firearms, because if a madman or mad woman, for that matter, comes into one of these public places, then there's a chance that they might get shot and people's lives could be saved.
Yeah. Just as from a legal point of view, had she walked into that, because you don't walk into a diner or wherever where this happened, you don't get searched. So had she decided to take her gun in for whatever reason and have it concealed, she obviously did the right thing. But just as a hypothetical situation, she'd been there when this guy walked in, and she had drawn a weapon and actually prevented her parents from being shot in the head and shot him. By what you say, then she would have actually been have acted in a criminal way. Would have been prosecuted for carrying a gun in a gun-free zone.
Quite possibly.
That's the ludicrous part of it.
I can't speak. Well, that's why she became a pro-gun advocate, because, and I must tell you as well that by far the majority of American states, if I say 39, I might be wrong out of the 51, but since the late 1990s up until present, I think it's 39 U.S. states have introduced concealed carry laws. Because before, and this went back to the so-called Wild West days, you had to carry a firearm in an exposed way, which has got certain disadvantages. So there's been a strong move towards concealed carry because of this type of situation. But the states certify the person to carry a firearm. Florida is a good example, one of the most recent ones, if I recall correctly. You have to be trained, you have to go and buy the gun legally, and then you have to apply for your permit. You go through a background check, you get your permit, you can carry a gun in public. And it's worked because violent crime has dropped in Florida. And that's but one of many examples.
Are you carrying a gun on you?
I'd never carry it on me.
Are you packing,
It's
Johnny?
in my safe. And it's
No,
been there for 30
I've
years.
never asked you, so I'm just checking.
Yeah.
All right. So because I mean, there's that's been that's a completely different scenario to what we're all following very closely. I just wanted to get some background. I think also put some perspective is how it works here in South Africa versus how it works there in the United States. I think the law in terms of this trial though would be different or not in terms of and we've asked every single person from Piet Bielefeld, Billy Gundelfinger, whoever we've had on the show about the trial. The one thread question that I have, which to me this trial is not necessarily about murder or not. At the moment, everything seems to be about whether he's lying or whether he knew Reeva was behind the door or not. Which, again, when I look at it, it's almost irrelevant because he took out a gun or he took his gun, he pointed it at a door. You can't deny that he thought someone was behind that door, didn't know someone, because that's why he did this, because he thought someone was behind the door. His argument, it doesn't know if it was Reeva, he thought it was an intruder. But the fact is he still deliberately pointed a gun and fired off 4 shots, knowing that obviously that would create some form of damage or even kill the person behind the door. Everyone has said that, regardless of who is behind the door, is still murder.
I'm going to put my lawyer's hat on for a couple of minutes and say that we have a presumption of innocence in this country and we're in the process of a trial, so the judge must make the decision, etc., etc., etc. Having said that,
is that not the basis on which he's going to make the decision, though, in the end, regardless of whether he knew or they haven't proven that whether Barry Roux can actually create enough doubt to say, well, Oscar's story is true, but is the judge not going to say, okay, well, he's not lying, we can't prove that he did know Reeva was behind the door, but he still shot somebody with intent behind that door with the intent to kill them?
I've got a slightly different approach to things because I like to build on what we have as opposed to speculate and try and prove what we think happened. So I would have approached this trial from an entirely different point of view. We have a bail affidavit signed by Pistorius, the accused. It's a statement under oath. So that is evidence, and it's going to be used in the trial. He says that I shot somebody through the door, turned out to be Reeva Steenkamp. I did it as putative self-defense. Now let's look at the requirements for self-defense. The first requirement is there must be an attack. He fails on that first fundamental requirement, let alone the other 3 requirements, which I'm not even going to go into.
So, well, it is an attack if someone is come into your house.
It's not an attack, because the next requirement is that attack must have commenced or be about to commence, and it must be of such a nature that you reasonably believe in the circumstances that your life or someone that you have an obligation to protect, that life is in danger. So if we look at the circumstances here, how can he tell behind a closed door what the nature of the attack is?
Exactly.
So as far as I'm concerned, on his own admission, and I want to stress that, he is guilty of culpable homicide. Now, culpable homicide is a serious offense. It carries a maximum imprisonment of 15 years. Doesn't happen in reality, but it's not to say that it cannot happen. I would have started on the basis that let's charge him with culpable homicide. It would have been a lot simpler, first of all. We have all of these experts, and we mustn't forget that in a criminal trial there must just be doubt. If there's doubt, there's no conviction.
If they had charged him, he would have then pleaded guilty?
Well,
or he would have been foolish not to plead guilty then?
If I had been his legal representatives, and again I speculate, I would have gone and said, let's do it on culpable homicide, because the sentence will be a lot less. And there was a distinct possibility that he would have been able to rehabilitate himself, he would have been able to get back into society, perhaps compete again, but most certainly it wouldn't have created the situation now where he's effectively painted into a corner. His reputation, even if he's acquitted, unfortunately his reputation is completely and utterly ripped to pieces.
Yeah.
So if I'd been his legal team, I would have said, let's do a deal on culpable homicide. If I'd been the prosecution, and what concerns me about the prosecution is within the space of 48 hours, they had decided to charge him with premeditated murder. That was before all of these forensic investigations had been completed. It was before they'd actually prepared their case. I fear that it may have been a little bit of a knee-jerk reaction, again, with respect to all the legal parties concerned, that's my opinion. And I feel that the prosecution may have also painted themselves into a bit of a corner where they've charged him with premeditated murder. To change that now, in the light of all of the controversy and all the attention, would have been very, very difficult to explain. And my fundamental problem is, with all of these experts, you have more and more evidence, you have more and more capacity for contradiction. And as soon as there's contradiction, there's doubt. And then it's a downhill slope from there, unfortunately.
Surely, though, if to charge him with premeditated murder, for the state to do that, they're kind of saying, well, let's go for it. And if he doesn't get found guilty, well, then we'll probably get him on culpable homicide at least.
Culpable homicide is what we call a competent alternative verdict. But again, we must first of all, one of the considerations to take into account is that the interests of society must be managed and it must be satisfied. So if Oscar is convicted, then society must be satisfied with the process and it must be satisfied with the sentence. Bearing those in mind, and all the controversy that now has arisen over the year and all the media interest, we now have a prosecutorial authority that looks like it's struggling. We have the police investigative units looking like they didn't do their job properly. It looks like it. I'm not saying that that is the case. Let me stress that.
Clearly, I mean, it does look like it, and it has since the bail hearing.
So now when we take the interests of society as a whole into account, was it right to put the state through this process and create all of this attention when our police look like they are, as we know that they really are, inefficient and incompetent? And I would suggest that it would have been a lot better for those interests, and they would have been served a lot better had they perhaps aimed a little lower and done a better job more easily and less controversially. That's my argument.
This is fascinating stuff. I just want to quickly go off the top and go, did anyone offer you tea, coffee, or water or something?
Glass of water.
Glass of water.
I get it.
No, Johnny. Kathy's listening.
We'll sort it out now.
Kathy's listening. So we'll organize you a glass of water. Can you just clarify, because I mean, this is the first point of difference that we've had compared to what Piet Beilerfeld have said and other people have said, who've all said that according to the law, if you are not threatened, or your life is not threatened, or you have no basis to argue that you were feeling threatened. In other words, you shot somebody without any justification that your life was under threat in any way. That is murder, not culpable homicide. Can you draw the line between what is murder, what scenario would have been what is murder versus culpable homicide?
Okay, first of all, we mustn't forget the concept of proof beyond reasonable doubt. What we think happened does not prove beyond reasonable doubt what actually happened.
We do know he did shoot her. He's admitted that, though.
The critical difference is, did he intend to kill, which would then make it murder in one or two different degrees, and I hate to use the word degree because we don't have that in South African law, or did he believe that his actions were lawfully justified? And even if he believed his actions were lawfully justified, but it doesn't stand up to scrutiny, he could still only be convicted of culpable homicide because he had a reasonable belief that his life was in danger or that he was entitled to use his firearm in those circumstances. The state has to prove intent. And I think this is an issue that's often overlooked. It's not what Oscar's actions looked like. The state actually has to prove intent. Now, intent comes in different forms. You've got premeditated murder, and if you look at the Chantal Henning case, premeditated murder where the guy allegedly paid someone to go and murder his wife. That's quite clear. That's premeditated. Then you've got direct intention, and I'm simplifying it. You get direct intention where I say, I'm going to kill you, John. That's direct intention.
Yeah.
Then you get indirect intention where I see John in a crowd of people and I don't like the look of him, so I fire into that crowd of people in the knowledge that my shot could kill somebody.
Yeah.
That's indirect intention. Then you get a very gray area of intention, which we call dolus eventualis or residual intention, where your actions are so reckless that the degree of negligence is so great that the state or the court can infer that intention actually existed.
Okay.
And that's where I think in this case the intention is probably, if it will be proven, will best be proven, the reckless nature of Pistorius's conduct may result in the state being able to prove that intention. Proving direct intention or proving premeditated intention, I think is very, very difficult in these specific circumstances because we mustn't forget and I think this is something that will come out over time. There's only one witness that's alive to this crime.
Yeah.
That's him.
Only one witness. Everything else is argument and inference.
Yeah.
And that is the weakness of the state's case, in my opinion.
The blurred line that we seem to be getting is that, and it seems to be a blurred line, is when is it actual intent? In other words, how close to the actual action of shooting somebody does it become intent? So in other words, I think what some other people are almost saying is, as soon as you raise a gun and aim it at somebody, if your life is not threatened, you're aiming at somebody, that your intent is then to shoot at them, and therefore your intent is to kill them, because you can't safely say you're going to pull the trigger, but you don't mean to kill them, you're just going to wound them.
No.
And if you fire 4 times, your chances are that much increased, that in a small area that you're firing, your chances are that you are going to do some serious damage.
It's not that simple, because you've got to explain your state of mind.
Yeah.
What did you believe in those circumstances? And there's been a lot of legal comment on this throughout the years. Our law is actually very well established and it's clear. And there's this phrase, and you might have heard it before, it's not an armchair test. You can't sit back after the event and analyze it coldly and objectively. You've got to put yourself in the position, in this case, that Pistorius was at the time. You've got to take into account the emotions. You've got to take into account outside circumstances. One of those big circumstances is going to be the fact that he is disabled. Another one would be his apparently very real fear that he was the target of opportunist crime because of who he is. You've got to the court has to put itself in those specific circumstances. You cannot simply say it's cut and dried if you weren't being threatened by somebody. You have to take into account that person's frame of mind at the time. And what follows from that is what we're all waiting for is Pistorius's explanation. He owes us an explanation. And if he gets into that witness box, and if he is a convincing witness and says, listen, I really believed that my life was in danger. Yes, in retrospect, I could have been wrong. But at that time, in those circumstances, when it was dark and when I was on my stumps, whatever he might choose to say, he still can convince the court that he believed his actions were lawfully justified. And if that be the case, then he cannot be convicted of murder because he did not have intent. You cannot say that somebody intended to do something when their state of mind clearly shows that they did not intend to do it.
So do you think then that Barry Rue advised him, because sometimes lawyers will always advise a client, I'm not speaking from experience or actual intimate knowledge, but it just appears that lawyers will always kind of rather discourage their client from getting up and speaking unless they really have to. Do you think Barry Rue's encouraged them for that very reason to go, you can put a strong case across, therefore go up and sit there and testify?
I can't speak for Barry Rue's specific discussions with Oscar.
But do you think that maybe that might have been the process?
I just looking at what evidence has been led and looking at the plea explanation, it was clear from the plea explanation that Barry Rue intends that Oscar gives evidence, because he said his client will say the following, and then he set out certain facts. And I think, again, just looking at the evidence, and I start from what I think is uncontested, and that is Oscar's bail affidavit. The rest we can argue about because there's two versions, but Oscar's version is a version of a person who was there at the time that it happened. Starting from that version, I still think Oscar has to explain himself. If he doesn't get into the witness box and explain himself, on that version alone, he could be convicted of culpable homicide. Now we have his advocate standing up and saying, Pistorius will testify as follows. I think he will get into the witness box. Not only did I say that he owes us an explanation, but we've got to give Oscar the benefit of the doubt. And it's all very well and good that we sit here for a week and a half, nearly 2 weeks, speculating and talking and discussing about what has been said. But we mustn't forget that we've heard one side of the story so far. Oscar has the right, the opportunity to get in and tell his side of the story. Let's listen to what he has to say. One thing I can assure you all, and the listeners in particular, is any attorney or advocate that does trial work will always tell you the truth comes out in court with proper cross-examination. So we have Barry Rue cross-examining the state witnesses. We see what happens there. Exactly that process will happen with Oscar Pistorius. The truth will come out with proper cross-examination. That is why cross-examination has been described as the single most effective trial tool to get to the truth in any legal system. So he owes it to us. Let's hear what he's got to say, and then let's make the judgments.
The other charges, obviously, which are all gun-related, and obviously trying to paint a picture that he was a gun-obsessed, kind of almost reckless individual when it came to guns. Have you seen all of that? And again, almost getting to the point where his defense are trying to actually say some of these incidents didn't even happen. My question is, why would these witnesses actually have any interest in going out there just to create these scenarios if they didn't happen?
I think we must look at those three unrelated charges on two levels. The first level is we must look upon it as being a second prize. So if Oscar is acquitted, there's still a second and a third and a fourth opportunity to convict him on other offences. Those three particular offences have a maximum sentence of 5 years. No one is going to be sentenced to 5 years imprisonment in isolation. In other words, if he's convicted or somebody is convicted on one or more of those offences, they're not going to get the maximum sentence. So they're the second prize. He might be convicted of those if he's acquitted of murder or culpable homicide. But I think the other level is that what Harry Nowell did was he put those additional charges in there so that Oscar has to give evidence. If he doesn't give evidence on those charges, he may very well be convicted on the evidence of the state witnesses. So Oscar has to get into the witness box to answer those charges, and he can be cross-examined about anything. So I think that it's worked on those two levels. And I think also what was in Harry Nowell's mind is, if I am going to try and get so-called character evidence in, then I can get it in this way by leading evidence of these other charges. A good judge, and I want to stress this, a good judge will see the difference between the evidence necessary to prove the offences and any possible character evidence.
Yeah.
And I think that we've seen that the evidence has been quite limited in respect of his character. There hasn't been any specific conclusions that have been argued by Harry Nowell or by Barry Rue at this stage in relation to the witnesses that have testified about the Tasha's incident and the shooting the gun out of the sunroof.
Yes, Simon.
I should ask, sorry,
Go for it.
yeah, you were chatting off air about you discussing the case, and you said you've been extremely busy talking to people about it. What do they want to know from you regarding the gun aspect of it all, and specifically about guns in South Africa?
That's a very, very pertinent question. The foreign media have a number of difficulties comprehending this tragic event, particularly the European media. They don't understand the concept of firearm ownership. So most European countries have quite restrictive laws, particularly in relation to handguns. So they don't understand that you can keep a handgun loaded at home. They don't understand that you can carry it in public. But most importantly, they don't understand how someone can shoot a woman behind a closed door and be out on bail. So there's a massive degree of ignorance in Europe about firearm ownership in South Africa and our crime situation. And with respect to the European media, they have reported fairly on it, but they come from a position where they don't know the basic underlying circumstances. And that's led to, I wouldn't say bias, but it's had to be a very fast learning process for them to get up to speed about what South Africa is about. And unfortunately, they've come here with preconceived ideas, not about gun ownership per se, although that has been an issue in some respects, but the general trend is they've come here thinking that we are a backwater with a bad legal system and a bad police force. And unfortunately, that message is still very strongly out there. And that's why you might have heard it from different commentators. It's not only Oscar Pistorius on trial. It's our legal system, our police, and our society in general that's on trial. There's a heck of a lot hanging on the outcome of this trial. And for that reason, I am fully in support of the media access to this trial, because it's only by seeing these processes on an unprecedented level that we can start dispelling those notions that we are that bad society that we're perceived to be. Or if we are that bad society that we're perceived to be, then the rest of the world can see it, we can see it, and we can do something about fixing it.
Fascinating stuff, Martin. It's half an hour's gone by already, and it's gone very, very quickly. It's as I say, it's always great to get just different perspectives on what's going on and see it from different angles. And we appreciate you coming through and chatting to us today.
My pleasure.
Thank you.
Thank you so much, Martin.
It's going to go for just try and clarify. Maybe you might be able to clarify, because they were saying earlier today that this case will go until its conclusion without interruption. Now I see something saying that they will. Court does have a break, I think, for a week, and they will reset the commencement date of the trial on the 11th of April. Now, it's definitely not going to be finished by the 3rd of April.
No,
It's supposed to be done by the 20th.
It's not. This is not. There's a bit of uncertainty, and to be quite frank, I don't know the answer. We've also debated this amongst legal circles, but the High Court has far more flexibility in terms of its own procedures. So the judge could continue until it's finished, but it would also be subject to whatever other prior commitments she may have.
And she does have one, I think, middle of April, where this was announced before this even started, that she does have another case written into, or whatever the legal term is, from the middle of April.
Then there'll be some sort of break. And in fact, if I can just add a couple of last comments, I'm very, very pleased that this matter has progressed as quickly as it has, because typically in these criminal trials, you tend to find that there's a lot of requests for postponements for whatever reason. So it seems that both sides have at least been prepared and willing to take the matter to trial. And I think what will happen is, once the state has finished its case, there will be a postponement in any event, because Barry Rue will want to have a look at the evidence, and then he's probably going to bring an application for what's called the Section 174 discharge, where he's going to say there's not enough evidence on a prima facie basis to support the fact that his client has to get into the witness box. So I think we will see a break before the conclusion of all of the evidence.
Well, it's amazing, because there's another one as well, another comment that says this has actually moved along at a very good pace, because a lot of the comments, and a lot of them from various quarters, are saying, gee, it's taking such a long time. But in fact, it is actually moving along, I think, from people in the know.
Yeah, you speak to Pete Bielefeld, and he says, well, he's been on the witness stand for a month for some of his cases.
Yeah.
I've concluded murder trials in a day, and I've concluded murder trials in 2 years with 6 or 7 court appearances.
Gee.
So if you just use that as a sort of thumbnail litmus test, you can see that this has progressed very, very quickly.
Martin, thank you very much for taking time to come and share your expertise with us, and also your insights as well, and some of your thoughts on the trial, and obviously the aspect of the guns as well, which is obviously a big part of it. Pete Bielefeld just finally saying that the one thing that will prove this is forensics and ballistics. Do you believe that as well?
I was initially, let me reiterate again, and I may have said this off air, the more evidence you adduce, the greater the possibility there is for contradiction and therefore doubt. So I have reservations about the fact that it's been done in such a technical or scientific way. I would have done it on a simpler basis, as I indicated, by charging with culpable homicide. Having said that, I am now of the firm view that the forensics are going to play a major role in this. But I do add the proviso, unfortunately, that forensics, although it's called a science and it's supposed to independently get to the truth, like anything else, you've got one version on the one side, you're going to have another version on the other side. Oscar will not call an expert that is going to confirm the state's version, because then he will be convicted. He's going to have an expert that will come up with an alternative theory or version. So yes, forensics are going to be critical to this, but it's going to depend on the strength and the credibility of those forensics.
The experts. Thank you very much, Martin.
Thank you.
Thanks,
Appreciate your
Pleasure.
time here with us at Balls. Fascinating stuff, and fascinating thoughts as well.
Balls.co.za